there are some shortcomings. Why do I use this word? Because that is very, very difficult in terms of the clarity factor. What is a relevant market is one of the biggest investigations that I would like to talk about. A person buying a 10 crore apartment and a person buying a 40 lakhs or 50 lakhs apartment are two different segments altogether. You can't say both of them are same. Tries to hold the market under its control, then CCI is definitely going to give the abuse of dominance factor there. Good morning and welcome to the session 4, unit 5 in commercial law, where we are going to talk about the provisions in the Competition Act of 2002. Now, moving further, under the Competition Act, the CCI can impose lower penalty on any member who's going to form a cartel on a first come, first served basis. And this is a very, very interesting factor altogether. What is a cartel? Cartel is a kind of an oligopoly market, which means 4 or 5 members, or let's say even about 3-4 members of a company join together. 3 companies join hand together and they start dominating the market. They don't allow a 4th or a 5th member to come up. They just want to control the market and create a cartel formation which restricts other companies to come inside. So that is going to be a dangerous situation altogether. Now, the first member of the cartel to approach CCCI, the Competition Commission of India, who fulfills a requirement, receives a 100% waiver in penalty. Now look at that. The first person to admit in the cartel and go and tell it to the CCI, that's the Competition Commission, sir, that yes, we were in the formation of cartel, the CCCI gives him a complete waiver. The Competition Commission says, okay, I am forgiving you 100% waiver in terms of the penalty factor, so you don't have to worry at all. But the subsequent members, number 2, number 3, are going to receive reductions up to 50% and 30%, but only if they provide additional valuable information previously unknown to the regulator. Now, this becomes a hide-and-seek kind of an arrangement altogether. So, the person who comes and discloses each and every information about the cartel is definitely going to get benefited. Why? Because the CCI gives him a complete pardon, gives him a complete position or a scenario where he says, okay, you have not been fined at all, we are leaving you completely there. On the other hand, if it is going to be persons who come later, the CCI is going to implement a 50% and 30% based on the level of information that they are going to disclose to the commission. Now, under the 3 brands of the reduction 150 and 30, only a single participant is eligible in each band, which means to say the first come first serve basis, where I'm going to talk about the first person who comes and admits the truth to the maximum extent. The first level itself, the person who is going to give out all the truth is going to get that 100% waiver. As you delay in this process, you start falling to the 50% and the 30% category, which is going to definitely hurt you in terms of the penalty. Now, the other thing is that once the first 3 participants have been granted leniency, no others will receive a favorable treatment. Suppose there was a 4th person who was also involved in this activity, involved in the cartel, but that 4th person is not going to get any sort of waiver. He is not going to get any sort of leniency or soft corner. Why? Because the CCI has got only 3 slots. In that 3 slots, the first 3 are already done, occupied, forgiven, forgotten. But the fourth person will not get that treatment. He has to pay the penalty. So the standard for disclosure is that it must be full, true, vital in respect of the alleged violations. Full details, forms of the procedures are set out by the Competition Commission of India, regulation of 2009 altogether. So when you are coming down to the Competition Commission of India and revealing the truth, saying that these are the things that have happened, these are the factors under which we have worked, these are the challenges that we have gone through. What does the CCI wants is a complete disclosure which is 100% true, which is 100% to the charges that have been framed against you, and which is something which is very, very discreet and clear. So what we want is a distinctive procedure which will be given by the CCI. They will give you a form which you need to fill up all the details, come back and tell the commission very clearly, these are the challenges that we had gone through, these are the factors, kindly provide us a chance, kindly forgive us for whatever that has happened. Followed by, despite the provisions of the Competition Act and lesser penalty, there are some shortcomings. Why do I use this word? Because that is very, very difficult in terms of the clarity factor. There's a very little clarity on what is meant to be vital factor here. Now, any company would not just come down and accept the truth. Any company will not be in a position to just go forward and admit to whatever has happened. At the end of the day, business is more important than just following the corporate governance and ethics, because business ideology is meant to earn profit. So I'm not here to sacrifice my profit and just accept the truth. What would be the case of investigating what is truly vital, why it is critical, and how it needs to be dealt with? All these factors are still under the dark shroud altogether. Why? Because sometimes the applicants may find it is impossible to determine their priority status in the race of immunity. So in the race of getting a 100% waiver, in the race of getting a clean chit, I do not know what exactly I have to go and disclose. I exactly do not know what I need to talk about the competition before the commission. I do not know what has to be listed. Though I have been given a form, I have been asked down to write all the vital information. Everything is fine, everything is fantastic, but I do not know what to be written. I do not know what is to be taken to the next level. I am completely stuck in that manner. So that's why I would say that I don't want to take this challenge at all. It becomes quite difficult for all of us to follow and take it forward. The next thing, Competition Act does not clarify whether the grant of immunity also means the whistleblower will not be held guilty for participating in a cartel. Now, the biggest challenge or the threat factor which I would like to say here is that if I go and disclose about a company's practice, their insider truth to the commission, will I also be considered to be innocent? Will I also be given that leniency altogether? That's a question mark. Why? Because the Competition Commission says that the company which comes first and accepts, fine, we are going to give them leniency, 100% waiver in terms of penalty. But what about that whistleblower who came forward and who admitted the truth and who said that very clearly that this was the reason? So are you giving him some kind of protection? Now that becomes a very big question. So that is where this factor of whistleblower is not yet being clearly explained here. Followed by the grant of leniency may not be actually bar the claims of compensation by third parties in the compact format altogether. Just because I have admitted to the mistake, to the guilt altogether, that doesn't mean that I'm going to go scot-free. the third party or the affected parties are still going to come back and ask for a compensation. They are going to raise a case against me and they are going to say that because of you, my business got destroyed. So you have to pay a compensation. You have to look into this matter. So I am not going to get a complete exemption by the Competition Commission of India stating that, okay, just because you admitted to the facts, I'm going to leave you. Now that is another challenge that comes in under this particular act. Now, these uncertainties may explain why there has been no leniency until now. So even though there might have been companies who had gone ahead, admitted their mistakes, admitted their follies, but still they have not got leniency, they have not got 100% waiver. In fact, there has been no single leniency at all. The reason is because of these kind of factors that are involved. Still, there are certain doubts, there are certain dark clouds which need to be clarified, which need to be explained threadbare. So that is why most of the people, in fact, none of them have got any kind of leniency once you have been under the radar of the Competition Commission of India. Followed by defining the relevant market. This is very, very important. What is a relevant market is one of the biggest investigations that I would like to talk about. In marketing, we always use this word called as the target market audience or the target market itself. Now, what happens here is that you will see that the market is already being set. It's already there. And there's a relevant market which is being done because of the abuse of dominance. So when I start investigating into this factor, CCI comes to this factor saying that relevant market is the narrowest possible way, which means to say that which area you are operating, in which sector predominantly the niche level of your target, so that you go and completely encompass them into that scenario is what makes things even more relevant. Now, for example, the NSE decision, National Stock Exchange, CCI contemplated whether the relevant market was the stock exchange services as a whole, or could it be limited to the smaller subset of services in currency or in derivative segment. Now you are able to understand. It is not the entire company, it is not the entire range of products which I am talking about. In which sector, in which area are you trying to play that dominance? Are you trying to become a monopolist altogether? So in the case of National Stock Exchange, when the Competition Commission of India raised a case, one of the biggest challenges was that they started looking into whether should I look at NSE as a whole, dominance in stock exchange services, or in derivatives alone, or in options alone. Why? Because only certain sectors have this specialty dominance, not everywhere. And you don't want to dominate the entire segment. You want to dominate in a particular area, in a particular segment, because you know the demand is more there. Followed by, the CCI took a view that in the case of NSE, exchange traded currency derivative market is fundamentally distinct from other segments on the basis of 4 factors. Now, the CCI came on the conclusion with NSE, National Stock Exchange, stating that the currency exchange derivative is distinct from the 4 segment. That is basically, if you're talking about the equities, the derivatives, the mutual funds, the hedges and futures and options, and then you start talking about the currency derivative. So they are different. The characterization of the exchange traded currency derivative segment as a new and distinctive segment of capital market by the Reserve Bank of India and the Securities Exchange Board of India. So now you have 2 more players who are guiding the NSE, because NSE cannot act on its own. NSE needs the approval of SEBI and it also needs the approval of RBI when it comes to the factor of currency exchange derivatives. Because foreign exchange is again guided and controlled by the RBI, and the SEBI has to give in the regulation factor for NSE to continue on its platform. So moving forward, the non-existence of currency derivative segment in Indian capital market continued until 2008. The number of players active in currency derivative segment market is also a very, very important factor, followed by the fact that informant MCX was present only in this segment because he was the only person in this particular area. So this is how they started leveling up the information. First, they understood the non-existence of the market. Until 2008, there was no one available. Number of players active in this segment are there, plus MCX being the informant, being the only dominant person in this particular segment coming into picture. Followed by the CCI conducted a cursory test whether consumers consider stock exchange services of currency derivative segment as interchangeable and substitutable by reference on basis of the characteristics, prices that are being used. Based on the analysis, CCI defined relevant market was only the stock exchange services in respect to the currency derivative segment altogether. So what does the CCI typically do is that they first gather the relevant information which makes a player become a dominant in a particular service or in a particular area. So it is not that by default I want to dominate the market, I want to hold the market, I don't want other players to come inside. It is by the nature and factor that through the operations, I slowly start gaining a dominance, I slowly start gaining a prominence, I slowly start holding a particular sector, and I see how the beneficiaries are also targeted. Followed by, with that conclusion, once we start moving to the next case, this was the case study of DLF. In DLF, that is one of the biggest real estate company in India, construction and real estate. Decision when assessing the alleged abuse by DLF, a real estate company, CCI adopted the fairly narrow definition of relevant market. Now, what was this case all about? The primary question was that whether high-end residential apartments in a small geographical region, especially in Gurgaon, would constitute a relevant market. Why? Because DLF was the prominent player there. DLF did not allow anybody else to come into the market. DLF was trying to play a very, very dominant role by selling the high-end apartments only there, and they had almost monopolized the market in the geographical sector of Gurgaon. Now, in its analysis, CCI distinguished between markets for high-end and low-end apartments and found that these two form two separate product markets as consumer preference for each are different. A person buying a 10 crore apartment and a person buying a 40 lakhs or 50 lakhs apartment are two different segments altogether. You can't say both of them are same. Suppose in Gurgaon, I am planned to buy an apartment which is worth about 15 or 20 crores, then my aim, my ambition is entirely different. But if I am going to buy a flat of just say about 4 or 5, 40 lakhs or 50 lakhs in a smaller version segment, then my choice, my lookout is entirely different. So they distinguish the market very, very clearly. Now, CCI dismissed the relevance of possibility that some buyers initially use such apartments for investment as opposed to the residential purposes. The CCI therefore defined the relevant market being one for high-end and the other one on the basis of consumer preferences for privileged amenities provided by the high-end complexes. Now, when a person is going to invest about 15 or 20 crores for his apartment, it doesn't mean that it's only for residential or for investment. Let's see, for example, there might be different meanings, different attributes behind it. But what was CCI able to conclude here is that one for the high-end residential apartments was primarily on the basis of consumer preference because the consumer wanted certain privileged facilities like a golf club, swimming pool, health club, fitness, reserved car parking area, all kind of first class amenities altogether. Because when I'm spending that much amount of money, I expect a level of luxury in the amenities segment altogether. So a person who is going to spend money in terms of lower segment, he will have a different ideology, different approach altogether. Now, what happened is that in each instance, CCI appears to have made one passing reference to be hypothetical monopolist test. Now, that is an economic calculation which is used to observe whether a small increase in price would provoke a significant number of consumers to switch to another product. So, we use this test to again see if price can trigger a person to move from one end to the other end as far as possible. But then, it is only the recent BCCI decision and that the CCI appears to overcome its natural hesitation in applying those economic tools altogether. What was the final analysis here is that the CCI examined the possibility of interchangeability between cricket match broadcast and other forms of entertainment programs by relying on empirical data, popularity of general entertainment television. Why? Because people might have that factor that because those areas are being highly looked after by the televisions and all other media, so people might get into those high-end market. But then they examine the interchangeability, whether is it possible. Because of this reason only people are coming there. Are there other forms of factors also? But then therefore, the CCI came back and applied the test to conclude whether viewers would not switch from watching cricket in just a television broadcast to other forms of general entertainment television program despite of increase in price based on the cricket match telecast, because those places had the stadiums and other kind of factors. So people might think that yes, these places are costly, where they have the live vision possibility altogether. The manner and depth of economic analysis in BCI decision are encouraging signs to understand the future abuse of dominance. Now, small towns like Mohali, or when you start looking in Noida, Ghaziabad, all these places started suddenly shooting up because of the dominance of IT companies and employment coming in. So now what happened? People who started building flats in those areas, the prices were obnoxiously higher when compared to other cities because of the factor that there were employment zone, people preferred amenities there, close proximity to work. So what the CCI typically tries to do is put in economic tools, put in the statistic valuations and see where exactly these things are coming into picture, where they are matching, where they are trying to go against each other in terms of the abuse of dominance. The dominant position. When assessing the dominance, CCI heavily relies upon the market share of the enterprise. Now, in the case of Kapoor Glass decision, one of the companies which was leading in glass manufacturing and DLF, CCI's finding of dominance was due to the high market share that we are talking about. Because DLF or Kapoor Glass has got a high market share, obviously their dominance in that particular segment in the market was definitely high. So that means to say that this was one of the reasons, primarily a reason through which you would be able to see that the dominant position was created there. The next thing is that, however, in NSE decision, we stood out of terms rather unusual approach was adopted. Why? Because CCI could not just go with NSE on one dominant position, and the currency derivative segment was also not only the one part. There were several factors, several players involved in that. So NSE to be dominant in one particular segment required a lot of approvals. So this was primarily due to NSE's relative large size resource base in the Indian capital market as a whole, because lot of people were dependent on NSE in terms of understanding the market, in terms of taking up the market. This was coming into picture. Now, in doing so, CCI has also linked the test of determining dominance to ability of the enterprise. That ability emanates from the act independently of its competitors, consumers, or relevant market. So what I'm going to talk about dominance is that irrespective to the market, irrespective to the consumers, irrespective to the economic conditions, if a company acts independently, tries to dominate, tries to hold the market under its control, then CCI is definitely going to give the abuse of dominance factor there. Followed by, despite recognizing the market to be dynamic in which the complainant and respondent had similar market shares, 34 and 36% respectively, NSE was considered to be dominant because of its ability to act independently apart from its competitors, setting and sustaining a zero pricing policy due to its deep pockets and relatively large market share factor. So what NSE did, it said, apart from BSE, apart from any other stock exchange like MCX and other factors, NSE started acting independently, started creating a dominance over the market, and they started understanding how things are going to go forward. And yes, it was a different scenario altogether there. So that's why CCI held NSE as a dominant abuse, because it went ahead, tried to do some practices which was against the competition, basically the anti-competitive practices. Now, without carrying any apparent economic assessment, CCI also concluded that but for the advantages accruing to the NSE out of the operations in the other markets, it wouldn't have been able to dominate, it wouldn't have been able to get everything done to charge anything for providing stock exchange services. So without any factor, NSE was not able to just operate in other segments and other factor without charging any services value. Now, the CCI's approach in determining dominance again highlights this factor, challenges faced, the economic analysis, where the company is dominating, how they are dominating, which competitors they are trying to bring in. All these factors have been taken in. So that is why, in spite of decreasing from 100% in 2008 to 36% in 2011, it was actually, NSE was still considered to be in a dominant position in the stock market basis. With this, I come to the end of this particular session. I hope and believe that all the information shared through this particular session would have been of a great value and resource to you. In the upcoming sessions, we shall try to understand more about the Competitive Act of 2002. Until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me today on this wonderful session today.